Well, it's not morning. Good afternoon. This is the first time I think we've ever done a brown bag at 1:30 in the afternoon, but that's because you guys have so much going on that this was all the time the only time we could fit it in. So I was just telling the gang that was here a little early that I'm going to be breaking with some traditions today because I'm leading with professional standards. I never have done that before. Fair housing, as you know, has become a really, 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 really big issue. And part of fair housing, of course, includes fair non-discrimination. So I'm going to mention a couple things and I'm going to cover a bunch of other stuff, then I'm going to come back. So I want you guys to be aware, if you haven't already read it, that there is a fair housing advisory. And you not only need to read it, but guys like you and other brokers need to make sure that you train on it. Because as I mentioned to all of the directors who are on this call, years ago, fair housing is now on the front burner, as it probably should be, frankly. There is something new, however, that really is going to be important. And I'm going to spend probably about 20 minutes on it in a short while. And that's last Friday, National Association of Realtors changed the Code of Ethics. And unlike typical modifications or amendments, they made the change take effect immediately. So as of right now, what I'm going to talk about, which is a new hate speech restriction, is in effect, and it will result, if you're found guilty of writing a letter or doing something relating to this particular standard of practice, it will be reported to the Department of Real Estate. And I was able to get a hold of a fellow that I did a program with from the DRE, so I'll give you that information. Those of you that are supervisors, that either are brokers or designated realtors who manage your office or oversee supervision, you need to understand that this especially falls on you because under California regulations, you're charged under 2725 of the regulations, subsection F, with training on state and federal fair housing. So it falls heavily on you. I'm also going to touch a little bit on the new fair housing regulations, because as you can see, all this is tying together: fair housing advisory, fair housing regulations, Department of Real Estate, NAR. All of these things are coming at one time, and you all need to be aware of what's going on. But before we do that, let's go over a couple of other things with you guys. And I don't know much more, so I'll answer questions if I can, but I'd be just guessing. NAR was sued by the Department of Justice, and apparently and I don't know the details. I've got a letter into the attorneys for your MLS, and so information may come in either while we're here or sometime this afternoon. But there's going to be a couple of changes to the way you guys do business at the MLS. First of all, NAR approved what you guys pretty much have already been doing, which is that I can file a complaint against somebody for a violation of MLS rules anonymously. You guys have been doing that with the button for years. But the other thing that they did is they said if you get 3 administrative violations in any given year, and I'm not sure if that's going to be calendar or year to year. In other words, I get my first violation today, so now we go through to November the 18th of next year. I'm going to get all that clarified, and we'll get that out to you. If you get 3 violations, it gets reported to the grievance committee. Okay. A couple of other things that the Department of Justice sued, and it looks like there's some type of a resolution. At least the trade organization indicated that is that the idea that you can report to buyers that your services are free is really misleading, and that's not going to be allowed in some fashion any longer, right? I've got my house for sale, and I'm going to be paying a commission to the realtor, and the realtor will in turn pay a cooperating fee to the buyer. And so when the buyer's agent says, I'm working for you for free, that's not true. Okay. Hey, Bill, good to see you. So that's not true. So that's going to change. I don't know exactly what it's going to look like. They're going to be making public access of certain data feeds, including offers of compensation, so that if Michelle puts 2.5% to the cooperating office, that's information now that the public is going to know about. That was a hotly contested issue at both CAR and NAR, and now it doesn't matter what the two organizations want to do. This has been something the Department of Justice, which is the plaintiff in this case, is demanding. There's going to be some other changes to cooperative compensation. I know that there's been some argument. There's a case called Morel in Illinois that is dealing with the question of compensation. The idea that I will list my property with Bill Tyler. Bill Tyler will then charge me, say, 5%, but then he'll turn around and pay Nadine 2.5%. Well, the reality there is what's happening is I'm really paying Nadine because and as a result, costs to sellers go up artificially. That's the position. And so there's going to be some issues there that are going to come down over the course of time. And then there's a really big change, and I really want to read about this because I think this is kind of scary. Under the Code of Ethics, under Article 1, Standard Practice 1-26, I'm to get my instructions on how to allow access to the property from my seller, and those are my instructions. Okay, if the seller says you can put a lockbox on, or in my case, by appointment only, however it works. And then the buyer in the standard of practice under Article 3, I think it's 3-9, but don't quote me on that. You can look it up yourself. The buyer then must follow those instructions if they're placed in the MLS. Well, one of the issues obviously is access to the lockbox. And I've had a number of those cases. I actually tried a case up in Sacramento last year. And so we've got to deal with these lockbox issues. And I'm going to read this. It says, with the seller's approval, so that's going to be critical to listing agents, with the seller's approval, a licensed real estate agent will have access to lockboxes of properties listed on an MLS system, even if the agent does not subscribe to the MLS. So I can tell you as a consumer, I'm telling Betsy, do not allow access through lockboxes. Here's how I want you to do it. And we're going to have these conversations, and you guys are going to have to figure that out. So that just came down today. Thank you, Denise Wilson, for sending me the text. I was fortunate enough because I get Inman. I got to tell you, Inman it's the one thing I can't live without. They really put a lot of cool stuff out. Okay, so let's talk about some new laws other than, let me tell you what's on the agenda today, other than fair housing. Forms, a couple of new laws, website issues, a DRE warning. We just did the MLS, so I'm going to strike that off my list. And then if we have time, we're going to answer some questions that came up on property management issues on Tuesday. And I'm not going to go over 3088, but if you've got questions about the new Tenant Relief Act, I've been living with it for the last 2 days. I've done a pretty deep dive into it. And so I'm frankly more confused than ever, but at least I can share my confusion with you guys in an intellectual way. So let's talk about forms. Not going to go into them with you in detail because they're available, but I remind you all that CAR has 12 new, as of October, COVID forms related to AB 3088. Let me say this. I know, Michelle, you're a property manager. I don't know who, I can't see. There's like almost 200 of you. But now is not the time. I said this to the gang on Tuesday, and I said it yesterday during a property management meeting. Now is not the time to dip into property management. If you or your people are not property managers, or you have an agent come to you and say, hey, I'd like to start a property management division, and you're not very conversant in property management, now is not the time to learn. These are complex. I was on the phone with Neil Kalin, who wrote most of these forms, about an hour ago. These are complex forms. They cover a myriad of issues, which I'll be happy to talk about if we have time today. So I just want you to understand that. I mentioned already the new Fair Housing Advisory. It's bundled with all of the CAR purchase agreements and with all the leases. So you're going to get it. And my strong suggestion, as always, you got to read it. It's got some really great stuff in it. It talks about the love letters, which I'll touch on later. It talks about some best practices, which we'll talk about a little bit later. So it's really a good form. And because of violation of fair housing laws can get you in trouble with Department of Fair Housing, Department of Real Estate, the board, you got to understand this stuff. It's no longer business as usual in terms of fair housing. It's not going away. All right. In December, you're only going to get one new form. So yay, a little bit of a respite. There's a new statute going into effect. Doesn't really apply too much around here. Has to do with properties where they are, quote, hardening the responses to things like fires, floods, all the things that California seem to enjoy a lot of. And so there's a new statute, and there's going to be a new form dealing with the disclosures that will be required. And that's the only new form. There are going to be a number of revisions on current forms, however, and the one that is going to be, I hope, very well received is the contingency for selling the buyer's property, the COP form. I've always believed, and I know I've talked to Barbara Horan and some others about this, Denise, you and I have had this conversation, that is by far the most complicated form for a couple of reasons. Number one, it's so many things you could choose from. And number two, you're trying to basically guess today how things are going to work out over the next 30, 60, 90 days. They're completely revising that form. I call it a revision, and it's not a new form, but I got to tell you, 3/4 of it's being rewritten. And so we'll do a newsletter, hopefully pretty soon, certainly before December the 1st on that form. And it's going to make it a lot easier for you to make some decisions. And it will also make it much clearer, in my opinion, and hopefully the opinion of the people that wrote it, the CAR attorneys. But it looks like it makes it a lot clearer that, hey, look, Carol, here's the deal. I'm okay with allowing this contingency, but I want you to keep the property in backup status. And if I get an offer, I want that contingency removed within 72 hours. That's in the form now, but those kinds of elections for the seller are much easier. And in a market like this, where you guys don't have much to sell, I think it's going to be very helpful. They're also going to modify the contingency removal form to reflect those changes. So if you do have a situation, the new contingency removal form coming out in December will have boxes for you to check off that relate to the new changes. And the notice to the buyer to perform is also going to be amended to reflect those same changes. There's a form that came out in June, the square footage advisory addendum form, the one that's supposed to be filled out by the sellers. They're modifying that form to make it a little more clear that these representations of how I arrived at the square footage of my house is not anything that the realtor had anything to do with. So they're going to clean that up a little bit. And then because of the changes in the law and the probability that 3088 will sunset in February, that's the Tenant COVID Rent Relief Act. Okay, just so you know what we're talking about, for those of you that are familiar with 3088. It's supposed to sunset in February. If it does, then they're going to modify the rent cap addendum and clean that up so that you guys will have that ready to rock and roll. A little bit of good news. You guys were supposed to get a brand new RPA. I'm sad because I was going to get to teach the class with Barbara Horan, and that's always fun. I learn something new every time I teach with her. We've had to put it off. I'm sad because they're not going to come out with the new contract until December of 2021. So once COVID is done, then you guys get to learn a brand new RPA. It goes from 10 pages to 16. They'll be revising all the forms, and Neil Kalin, who heads up that department at CAR, said we're talking about 60 to 70 forms. So COVID will probably be over, hopefully by July. Maybe house arrest will be over, and then you get to learn a new form. So we'll start training. Connie will make the decision. We'll talk about how we're going to do that. There's a couple of ideas, but that comes out in 2021, December. Couple of new laws not related to rents and not related to fair housing that are going to go into effect on January the 1st. There's a new law that clarifies property inspectors are independent contractors. So if a property inspector does not have, it works for you, unless you employ them under the rules of a case called Barillo, they're going to be, it's clarifying that they're going to be independent contractors. HOAs, homeowner associations, must allow, under the new rule going into effect on January 21st, regardless of any other restrictions they put into effect, that rentals, not Airbnb or those, but actual rentals, month to month or long-term leases, they must allow up to 25% of the properties to be rental properties. That doesn't mean they have to, but up to 25% of the owners can elect to rent out their properties. And if they are below that 25% figure, they cannot stop that by rule, regulation, or restriction. There's going to be some changes to the PACE laws. There's going to be some significant changes to the way we collect debt. And so if there's any lawyers out in the room, be aware that there's going to be some changes. And if you get a judgment against someone for a consumer debt, under the current law, you can go after the home that they own. That will no longer be the case. And then they're increasing exemptions and homesteads for homes to a much higher number in addition. So also, and this is something that we'll talk about next year, but right now, there's going to be a new law that says that if a property goes into foreclosure, that a tenant has 45 days to buy it. Now, I don't exactly know how that's all going to work out. It can be very complicated, but there was a bill that was introduced in this last legislature. It actually came out of San Francisco, and it actually has already been passed in Cincinnati, Ohio, and in Atlanta, Georgia. And that bill will basically say, before I can sell my residence, I have to offer it first as a right of first refusal to my tenant. Okay, and while that's not necessarily bad, I know a lot of people I've represented have done that. Sometimes they can qualify, sometimes they can't, but it puts some pretty stringent rules on how long that's going to take. So it could add a substantial amount of time between when you want to sell the property and when the tenant responds back. And you also have to give them a right of first refusal once you get an offer. If that bill passes, now bills get gutted and amended all the time. Gino and Adam and Walter can talk about that. But we're going to be having a meeting. I'm attending. I don't know who else, but on December the 10th with your lobbyist. And so I'll report back after December the 10th. I'm sorry, December the 4th. Excuse me. With your lobbyists and with June Barlow at CAR and a couple of other lawyers that do what I do, about 12 of us, we're going to get together on December the 4th, and we're going to go over next year's legislative package, and then I'll report back to Connie, and she'll decide how to disseminate that information out to the rest of you. Because remember, this year, Gino pointed out to me, Gene Wunderlich, that there were 5,400 bills of one sort or another that got proposed, and they only passed about 300 of them, which was about half of what they normally pass. So, and the reason for that was because they didn't meet. They were shut down by COVID, just like everybody else. And so they're going to be busy next year. And they got a couple of punches in the face on this last election. 15 didn't pass, and that was a legislative initiative and a couple of other bills. So they're going to be busy, little beavers. And
John?
Yes.
So there's a few questions accumulating on the chat. Do you want me to interrupt you, or just save them till the end?
I always enjoy when you interrupt me, but let's if it's specifically about something like this, yeah, go ahead. Just go ahead, and I'll try my best. But I want to finish my thought that And my thought is a plug, and it's totally, Connie didn't ask me to do this, Adam didn't ask me to do this. Next year, you guys are going to have a heck of a legislative agenda, because this legislature is now in one of the two houses even more of a one-party house. And so you guys are going to be nibbling around the edges on a whole lot of stuff. And if you understand politics, you understand it's about money. So when they come to you or you need to write a check, again, I don't know your finances and I'm not going to preach at you, but certainly don't whine about the amount that's in your dues. But if you can afford more, pay more, because there's private property is really going to be taking some hits next year, I believe. So what was your question, or what was the question, Sylvia?
So we have quite a few. So the first question came from Joe McGowan. Do you recommend use of all square footage addendum in all transactions, or only where there is a discrepancy between sources?
Which form? I'm sorry. I didn't hear.
Square footage addendum?
I don't recommend it at all. That's really your call. It's not a mandatory form. I know that square footage is a really an inartful science. And so you can, if your seller's willing to fill it out, if the buyer's asking for it, yeah, but you need to make sure that it's clear as it can be, that this is an estimate coming from the seller, that you have nothing to do with it. But to say I recommend it, I know it's popular, but I'm a risk manager. I never sue you guys, and so I would prefer, not to see you do that. But I'm open to argument about that. It's really an office by office decision. Any other comments? Okay.
Yes, I'm going to go ahead and unmute Roberta Ellers. She had a question. It just says only when the property is in foreclosure, so I'm not really sure. So Roberta, if you want to go ahead and
give hold that question till later. We'll jump back. I'm going to save a half hour. I don't want to really blast through this stuff.
Okay. Real
quickly, at both CAR, I just attended lawyer meetings at CAR and at NAR. Unfortunately, we didn't get to go to New Orleans. We had to do this on virtually. Very sad for all of us that get to go to these meetings. But at both meetings, they had lawyers come in to talk to us about website access. So really quickly, a couple of things. We'll deal with it a little bit more. I know that there have been some lawsuits filed by ADA lawyers in this area. I know there have been some in Hemet. There's been some in Temecula. So there are these, I don't know, for want of a better term, bottom feeders that are out there. And so just be aware of that. First of all, understand that in California, the courts have made it clear that your website, because websites have proliferated so much that it's an integral part of everybody's business, it is deemed to be part of the brick and mortar operation. In other words, you must provide a reasonable accommodation for persons with disabilities such as hearing or sight impaired. Basically what they're talking about, and Bill, I'm not much of a computer guy, but what they're talking about is modifying your website to allow the applications that a person who has a disability might have. There are applications out there, has to do with how your IT guy sets it all up. There's an organization, and they've come up, it's not a government organization, there are no government guidelines, but there is an organization that has a set of compliance recommendations. And the court in the Domino's Pizza case, which is a Ninth Circuit court, said that those would suffice. So I'm gonna do a newsletter on that down the line. So bottom line is a couple of things to suggest, and then I'm going to move on because I really got a lot to talk about today. But minimally, it's going to be $4,000 penalty plus attorney's fees. So even if you do it and make one mistake, it's going to cost you $4,000 plus whatever they charge. And these guys are charging up to $5,000 in attorney's fees. So it's going to cost you, an average of the average department running about $14,000. So put something on your website, or have your IT people put something on your website that says, if just like what we do at the board, if I'm hearing impaired, I can contact the board if we're live, and I can say I need some type of a of a device that will help me amplify sound, right? Or have the speaker yell at me. But no, we'll do that. And so have something on your website saying, if there's a problem accessing this in any way, here's the phone number, please call, and we'll accommodate you as best as we can. And then talk to your IT people about what it's going to cost to bring all that up to speed. The Department of Real Estate, this is important. I will tell you that in talking to the MLS people and talking to professional standards people, as you know, I represent 8 realtor organizations from Ventura all the way out to Palm Springs and south into Orange County and Long Beach. And in talking to people, there seems to be this idea that these rules that the CDC has come up with, wiping down the house and putting the sign on the front door, don't apply to you, right? I mean, you probably know agents that, we don't do any of that. We're going to line them up and let them come in. We're going to do open houses. This is all political. It's nonsense. We don't have to follow that rule. The Department of Real Estate has made it crystal clear that if they catch you, at a minimum, you're going to get a fine up to $2,500. And the DRE commissioner made it pretty clear that if it's intentional and it's habitual and it's office-wide, it's going to be an accusation which could lead to a suspension or revocation of your license. I point that out because while these rules are complicated, while they're difficult, and in some cases, frankly, make no sense, you need to be aware of them and you need to at least make a good faith effort to comply with them. Period, end of story. If not, make sure that you have your lawyer or my phone number handy, because you're going to get in trouble. You're going to get fines. You're going to get sanctions. It's going to be very, very difficult. I've just finished 2 DRE complaints. And the other problem with that is that it's also incredibly expensive to defend. I don't care if you're innocent or not. In one case, they dismissed. The other case, we're working on a resolution. But both cases, I got richer, right? And that's not a good place for you guys to be. So be careful about what the DRE is saying. Let's talk now about what's going on. I have all kinds of information about AB 3088, and so I want to save some of that time for later. So right now, I want to talk about fair housing a little bit, and the reason I do, and you're not going to like what I'm about to say. Some of you may. I think it's time that some of this happened, but because the way NAR has set this up, where if, let's say I don't know if there's any grievance people out there, any professional standards people out there. I know Denise, you're one, but if there's other hearing officers out there, I know Bill, you're on grievance. If there's going to be a situation where you do something in violation of what I'm about to tell you, it's going to be reported to the Department of Real Estate as a discriminatory act, which is a violation of your duties under the California real estate law. And it could conceivably, if it's severe enough, certainly lead to a public reproval, which stays on your record forever. It could be a suspension, which means you're out of business for a short period of time. Or if it's really bad, it could be a revocation of your license. But at the minimum, it's going to cost you a bunch of money. It's going to cost you money because the board's going to fine you up to $15,000. It's going to cost you money to hire a lawyer to defend you. That could be $25,000, $30,000 if it's an accusation to get your license. If you're cited, it's going to be anywhere between $1,200 and $2,500, right? So, and more importantly, and this is my personal opinion, this isn't Connie or the board, this is me. It's not Tyler Bursch, it's not any of that, this is me. And I believe Tyler Bursch believes in this as well, and I'm pretty sure I know Connie for 20 years, she believes this, that it's the right thing to do. Maybe the way it's going to get enforced or the kinds of issues we're going to talk about around the edges are going to be problematic, and we're going to have to work those out on a go-forward basis. But the idea that you would be writing letters, hate speech, things like that, so are just reprehensible as your duties as a realtor. So Here's what's happened. Let me talk about the background first. I was a history major, so you have to bear with me when it comes to background, because I have to understand why something is before I can explain it. We all know what's been going on out in the public with social unrest. You can agree with it, disagree with it, agree with parts of it, disagree with parts. But I think all of us that are intelligent people understand some things are perfectly valid and some things are a violation of law, other people's rights, all that. But clearly, this is not a subject that's going to go away, particularly now with a new administration most likely coming into the White House. And so we've had just a tremendous bright light shined on social media, through social media on issues relating to all forms of discrimination. But in real estate, it's historical. There's a book, and I highly if you're a reader, I highly recommend this book. It is called The Color of Law. It was written by Richard Rothstein, and I got like I said, I got my degree in history. It sort of charts. I mean, when we think about today, people, because we don't teach history anymore, we tend to think of everything in the context of today. But the reality is that historically, government has been a perpetrator, and NAR has been a partner of all kinds of racial discrimination, everything from redlining and FHA rules and all kinds of stuff. This is a great book to read to kind of get an idea. So you've got that. Then what happened is in Long Island, New York, 2 years ago, a year or two ago, Newsday did a 2 or 3 year study. What they did is they trained a whole bunch of what we would refer to as testers, okay? People that would go out looking for properties, people that were African American, people that were Hispanic, people that were Asian, and Caucasians. And they all went out and they went to about 100 offices, all of the big ones, and they asked questions no different than any typical buyer would do, right? Where I want to live, what I want, this, and through that 2 year study, which was a major news article, there was a documentary written about it. It was in newspapers. It got awards. They established that at least in Long Island, New York, over almost 50%, 49 point something percent of the Black prospective purchasers were discriminated against in one way or another, usually through steering, where you don't want to look in that neighborhood, let's look in this neighborhood. It could have been through other forms. In some cases, it was just blatant discrimination. But usually these kinds of discriminations in today's day and age tend to be much more implicit, much more in terms of, not at the surface, so to speak, but nevertheless, it was clear. And to the point where a lot of these realtors are now being brought in under subpoena to explain themselves. And so NAR was incredibly embarrassed, as they should have been, because these were all realtors, every single one of them, every single one of them. And of course, now you're on the news, and you guys aren't, with all due respect, I know you think lawyers are bottom feeders, but Gallup did a study, and you guys aren't that far ahead of us. And so the reality is that you already have in the minds of a large segment of the population sort of a mark against you, and now you've got this, and then the sort of the thing that pushed it over the edge was during the summer, the riots and the things that most of us think were not appropriate, whatever your politics are, led to some really crazy social media postings. And social media has become a field day for lawyers, frankly, and things that were just reprehensible. And so NAR said, you know what, enough. We got to do something about it. They've hired a guy named Brian Green, Harvard graduate, #2 man at HUD. They brought him in as the new vice president of diversity, and they started making plans. They went to professional standards, and they said, we got to make a change to the code of ethics. Okay, so that's the background. I did a program with Brian in September. He's a brilliant guy. So again, I'm going to talk to Connie about this for early part of next year. about maybe putting somebody like Brian or Brandon Butler, who's the attorney I've been dealing with at Department of Fair Housing. But these are huge issues. These are policy issues. So what did they do? Well, they have made 3 changes that will affect your day-to-day life. Number 1, they've changed the bylaws under which NAR operates. And they have said under the current, under the bylaws that existed on November the 12th, it said that the Code of Ethics and your conduct is applicable to your real estate activities, and that it is strongly recommended that you follow these principles in all your activities. Okay? So they changed that. And now the Code of Ethics is applicable in all your activities. Period. End of story. The idea being that you can be a realtor in the daytime and a racist bigot at night, or a homophobe at night, or this at night, and you can, sell property during the daytime and then go somewhere and speak, the way people have been speaking is been done away with. Now, obviously, not everything you do is going to be related to the Code of Ethics, because a lot of the Code of Ethics is very specific to real estate. Article 9, all your real estate transactions need to be in writing, right? So those kinds, that doesn't mean I can't sit down with Michelle and have a verbal contract, because the law allows us to do that. We're not talking about that. So let's not go nuts, okay? It's talking about things like me writing a letter to Denise saying something racial, something hateful, or me writing a letter to a person in Palm Springs board that I represent, which is a very strong gay population, and making some kind of a statement not related necessarily to real estate, right? That's going to get you in trouble, big trouble from now on. So that's one thing that they've done. Number 2, they've indicated that that if you are found in violation of Article 10, that you will be reported to, or you commit fraud against a person in one of the protected categories, of any amount, you will be reported to the Department of Real Estate. Now, they tweaked it a little bit on voting day last Friday. And it's interesting, because I'd had a conversation with the chief investigator up in LA, who handles the San Diego office as well. Because here's the thing, under California law, if the Department of Real Estate gets a complaint against Shannon, say, for example, I'm picking on people I can see, by the way, so you turn your cameras off and I'll leave you alone. I'm kidding, don't do that. But if a report is made against Shannon of a discriminatory conduct, and it's sent to the DRE doesn't have jurisdiction over things that are not related to real estate, right? They're not people that come in and deal with, did you have too many people for Thanksgiving turkey, right? That's not a real estate related activity. And so what they told me, they weren't going to be able to take any of those claims, but they would probably report them to someplace like the Department of Fair Housing and let them deal with it. And so they did clean that up. And so as far as public trust, it won't get reported to the DRE unless it's related, but it doesn't have to be related to a real estate transaction. So if Bill writes me a letter and says something relating to real estate, let's keep Marietta White, right? Or let's keep the Colony, whatever we could say. That's real estate related, even if it's not related to a transaction he might be working on. You understand the distinction? That will get reported to the Department of Real Estate. So they also made a change to the article itself. So let me read you, and I know this is, hopefully you'll find this helpful. Here's what Article 10 says, and it's not changing. Realtors shall not deny equal professional services to any person for reasons of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Then it goes on to say you won't be a party to any of that type of agreement or any of that type of conduct. So like those old blockbuster guys and all the stuff that's gone on in the past. And you're not to discriminate in your employment practices. So if I won't hire that house inspector because he's gay, or I won't hire that plumber because they're Middle Eastern, those kinds of things. Well, that's not going to change. I want you to notice one thing though here, because you kids are all in California. This is the NAR standard, and this is what we're talking about. Separate and apart from this, under completely separate sets of rules, which I'll talk about in a few minutes, we have California law. And we don't have 9 categories in California. We're up to 22, right? We have things like age, immigration, language, military status, on and on and on. So this will not impact those categories, unless, of course, an immigrant can also be brought in under a race or ethnicity claim. That's different. So what they're changing, however, is standard of practice 10.5. And I'm going to read it to you if I can read my handwriting. Realtors must not use harassing speech, hate speech, epithets, or slurs based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. So this means in your speaking, it can be verbal or it can be in writing, okay? It can be, that's very clear. One component of it is it's made very clear for those of you that attended the sexual harassment class last week, that it applies to sexual harassment. So if I do something to harass Michelle and it's a sexual harassment, not only would that be a violation of California law, but it would very conceivably be a violation of the Code of Ethics under this new provision. If I did it in writing, so I sent some kind of a sexually explicit document, or I made some type of a comment, or I threatened a woman or a man, because again, about 30 some odd % of the claims are being filed by men. We're changing a lot of stuff. And so there's a whole social media kind of a thought process. And so this applies to social media. It also applies to verbal. It applies to letters. And I'm going to read you the definitions in just a second of what those actually do mean. So let me read them to you now, just get them out of the way. So hate speech. And Webster's Dictionary, right? Now the new one is called Merriman. I'm too cheap to buy the new one, but it's the Merriman-Webster Dictionary, right? And that's what NAR says we're going to use. So it's a standard definition found in a dictionary for these things. And number one, what is hate speech? Speech that is intended to insult, offend, or intimidate a person because of some trait. In this context, the trait would be race, color, ethnicity, things of that nature. So again, the key word there to me, and if there's another lawyer on the call, I would love to hear your thoughts, but it is intended to insult. So the word is intended. This isn't going to be every little thing you say, right? But intent can be both specific and it can be general, right? I may not intend to burn your house down, but if I'm playing with matches, there's a good possibility we're going to have some problems, right? So it's going to be judged by who? By professional standards, right? That's the people that are going to judge. So Connie has already asked me, and I've already put it together. We've just got to schedule it. We're going to have a meeting probably the week after Thanksgiving. Her call, not mine. I work for her, work for the board. But we're going to have a meeting, and we're going to go far deeper into this. We're going to have a chance for everybody to vet their own comments. So Bill, get ready. It's going to be fun. What's an epitaph? I had to look it up myself, because an epitaph is a characterizing word or phrase accompanying or occurring in place of the name of a person or a thing. So instead of referring to a person by her name or his name, I refer to that person in a racially negative tone or in a sexually explicit tone or something like that. That's an epithet. And it can also be a disparaging or abusive word or phrase. What's a slur? Other than if you've drank too much, one of the definitions is it's an insulting or a disparaging remark or innuendo. It's basically a shaming, and that's a pretty popular term nowadays, or that has a degrading effect. These are tough definitions. So let me blast through, and then if there's any questions, and there's 32 of them, so I suspect we'll be chatting about some of this stuff in a minute. It became effective on November the 13th. Normally when they pass a code of ethics change, they don't do it until the first of the year. They made it immediate. It is not retroactive. So if you were stupid enough to write something bad, let me give you an example. I have a director at another board that wrote something about that damn Obama Muslim president, right? And he did it in a pretty disparaging way. Today, he would be in some deep trouble. This doesn't affect that happened back in June, okay? I know some of you are going to ask me, so let me get it out of the way now. It has nothing to do with impinging your free speech. The Constitution of the United States of America, you guys remember that when they used to teach it. The Constitution of the United States says in the First Amendment that that Congress shall pass no law infringing upon free speech, upon freedom of association, and upon freedom of religion. So it's Congress. It means there's got to be a state federal action, right? And then the 14th Amendment of the United States Constitution, when they passed that constitutional provision, expanded it to the states, which is the debate. I know that Bill's brother, Bob Tyler, has been fighting tooth and nail with the governor over all the closures of churches under the theory, you've taken a state action to close these churches and you've done it in an overbroad way, even though there's a public, and there's been allegedly a pandemic. So that's what we're talking about, is the state has taken action, right? But NAR and CAR and SRCAR are not governmental agencies. And so trade organizations, clubs do it all the time, right? They will say we don't talk like that here, right? We don't talk like that here. And so just get that out of the way quickly. It's not an impingement on your free. Yes, it's an impingement on your right to say things that you shouldn't say, but it's not a constitutional impingement. And no, it's not going to be everything you do. It has to be related in some way to an intentional act and those kinds of things. So as you can imagine, and this is probably do cover some of this stuff at the first brown bag in 2021, if I'm asked to do that. This doesn't mean you have to agree with the position. I can agree with, there are political things out there that maybe Denise and I disagree with. I'm allowed to still do that, but I don't sit down and call her some kind of a derogatory name relating to her race in order to get my point across. We talk like adults about whatever it is. You understand that? I mean, I can have an opinion and it can be different. I'm a pretty conservative guy. I have opinions that are far different. Well, my son was the photographer for Bernie Sanders. So we have arguments all the time, as you can imagine. And that's okay. But what I can't do is if he were, say, a person from another family, I can't use his race or the fact that he might be have a sexual orientation different than mine. That's not what we're talking about. They're going to be looking very carefully, because this came up in the Long Island situation at appraisal issues, right? What they did is they had someone go in, and there were pictures of children, family on the mantle, and they were black, right? And the property was appraised. Then they took those pictures down and they put photographs of the owners who were then white, and the properties were consistently appraised at higher numbers. Okay, so they're going to be looking at stuff like that, as they should, in my opinion. They're not going. Freedom of religion has come up a lot. right? If I'm a pastor and I'm also a realtor, am I going to be allowed to make a comment about what the Bible says about homosexuality, those kinds of issues? What if I put a Confederate flag on my bumper, right? Those kinds of conversations are going to be had between now and next. We're going to be having those conversations. I don't know the answer because I'm not in charge of your board. I'm not in, NAR is going to be writing up what they call case interpretations. What about social media? I got to tell you, kids, social media is wonderful. My son-in-law works at Google. Yay for social media. However, you guys got to be careful what you say. I see with these Facebook groups and other places where people are putting stuff on social media, and they think somehow they're, immune from any kind of liability. Is simply not true. So be careful about that. And then for you brokers out there, remember that number one, the Department of Real Estate is looking to you to train your people. You have to have training. Now, the training can be done through the board. The training can be done through CAR. The training can be done how you deem appropriate, but the training must be done. Okay? And you should get that training out there as quickly as you can. And of course, set an example of how this conduct should look. Again, CAR has done a wonderful job, in my personal opinion. That Fair Housing Advisory is a great place to start. There's also a bunch of frequently asked questions. There's a bunch of Q&As. There's not going to be any shortage of information. I'll work with Connie. We'll make sure all that stuff is on your website. Connie does a really fine job on that. Here's the bottom line. I talked to Brandon Butler, who's an attorney at the Department of Fair Housing, and he said, look, here's the deal. I'll pick on Denise for a second as an African-American woman, right? Well, we're negotiating, and a beautiful one at that, and she knows that I party just every bit as hard as she does. We've been on cruises with her husband and my wife. So here's the deal. She and I can negotiate, and we can disagree vehemently about real estate, about the price of a house, about whatever it is, right? But if I zero in on a character, what should it be? What should the discussion be about? Price, terms, location, those kinds of things, unrelated to race. It's when I start using a characteristic of her background or her religion, or maybe if it's someone who is gay, that's where you cross the line. The characteristic, if it's related to one of the protected categories, and in California, of course, that's 22, but talking about at this level, that's where we start crossing the line. Okay, that's where we start crossing the line. So it's the characteristic ought not to be a characteristic related to one of those protected categories. And then, of course, there's going to be some special issues we're going to be working on. I'm really looking forward to this weekend because I'm tired. But we're going to be looking at issues like, hey, Gail, how are the schools in that neighborhood? Right? That's a dangerous trap because you can get into some really tough issues. Well, the schools over, you really don't want to look at the schools over there because they're in an area that's not very good. And, you start getting into those kinds of discussions, right? You got to be really careful about that. And then, of course, location issues, right? Again, when you look at what CAR did a really fine job, in my view, of laying out best practices. And so go back and take another look at that form. And then, again, we've done the definitions. What about enforcement? I don't know. We haven't had the meeting with professional standards yet. I know Connie, like the moment that the thing got passed, set up, got to do professional standards. I've got it ready to go. I've got a bunch of really fun hypotheticals. I would love to take this class. But I'm really going to be interested in hearing from the audience. And it's, my job is going to be to keep it cool, right? Because there's going to be some passion, there's going to be some emotion, and my job is going to be to not let that happen to the extent that I'm worried about. So let's talk about some special issues. Been an awful lot of talk lately about the so-called love letters, right? The buyer letters. NAR, I have a letter here I could read to you from the attorney for NAR. Her name is Katie Johnson, one of the 2 or 3 smartest people on the planet, and she's very concerned about the love letters. Why? So I write a letter to Sue Lopez, and I say, or Sue's client, and I say, I'm so looking forward to living in your house, my children are healthy and they can't wait to be able to walk to the park, or the schools are great and blah, blah, blah. And then I give you a photo and it's white or something like that. You can see where those can lead in a very serious way to some unintentional, frankly, fair housing. So what NAR and CAR and CAR's got a quick guide on their website. There's also some slides on the website, but they've made it pretty clear that and I've talked to Ed Zorn about it, who's the attorney for CRMLS, that if I'm representing the seller, as part of my conversation with them, you need to have an adult conversation about these letters, right? Because I have a case right now where the letter was the reason that they had 14 written offers in 2 days, right? And you guys are going nuts in some of those cases. And the woman who was the seller was a kissy, feely, touchy kind of person, and the love letter got to her, right? Well, I could see very clearly how that love letter, because there were photos, you're talking about, I can't wait, we will blend in so well with this lily white Wonder Bread neighborhood. You know, she didn't use those terms, but you know, those kinds of things. I could see where that could be a significant problem. So if I have time, I'll answer some questions about that. Again, we haven't even touched on California fair housing, right? We haven't even talked about it. California fair housing is a whole nother thing, right? You've got 50 pages of new regulations that talk about sales, that talk about landlord tenant, that talk about so much. And so I'm prepared to answer questions. I can go into that in a little bit of detail if you'd like. By the way, this is the buyer love letter slides. Can you see that okay? They're on the CAR website. It's about 6 pages of slides. Here's the buyer quick guide on the love letters. They're not calling them love letters, they're called buyer letters. So I'm now gonna have a conversation with my seller. And I'm gonna say, and of course, we're now gonna have a conversation about lockboxes based on what happened at the Department of Justice today. But I'm also gonna say, okay, Shannon, or Shannon's gonna say to me, you know, I really strongly recommend that we limit or even eliminate these love letters, right? And have your seller confirm in writing with you they don't want to see any, and then put it in the MLS, right? That's one way. Another way would be to simply indicate, we're not going to look at them. We're not going to touch them, right? And we're going to strongly recommend that, or if we do, we're going to run them by the broker. In some cases, maybe even run them by our lawyer if we're concerned about the content. And we may actually even reserve the right to redact some of those letters if we think it's relating to some type of a housing issue. Again, I can say, hey, Philippe, I'm interested in your house on Maple Street. It's close to my job. It fits all my demands. It's affordable. I'm really looking forward to it. It's the right size, all of that kind of stuff. But you just got to be really careful about that implied kind of a bias. Another thing that you might consider doing is you might consider going on to NAR's site. I did this recently in preparation for a program I did with Brandon and with Brian. I grew up in a generation much different than, say, Shannon's or Michelle's or some of you munchkins, Denise, right? I mean, we grew up in a different generation, and I know I have and concerned about implied bias just because of how I want to live my life. And I see NAR has on its website, just go into fair housing. You guys know how to do all that. And they have a 52-minute video, and it's excellent, on how to spot implied bias in your own life, right? What to look for. And it was eye-opening for me, you know, because I grew up in a generation where you could make jokes about homosexuals and it was funny. I grew up in a generation where you could talk about women in a certain way and it was funny, or we thought it was cool because we didn't know any better, right? And those things are no longer socially acceptable. And I had to figure out how deep does this go in terms of my own personal upbringing and the things that my immigrant grandfather and my once removed from Italy father talked to me and said to me in the words that they use to describe certain kinds of people and all that. So I strongly recommend that you consider doing that. All right. Well, there's only 41 questions. So Sylvia, is there anything that you want to stop and we'll go over right now? I wanted to touch on, I got a bunch of questions from some of you guys, and I want to, at least honor and answer those questions. And frankly, they were great questions. I actually had to exchange correspondence with other lawyers to get answers. So thank you for playing Stump the Lawyer. It's appreciated. So Sylvia, let's have at some of these questions. I don't have them on my screen.
Hi, John. Daniel here. I have a couple questions for you.
Oh, Daniel, hi. Good to see you.
Going? Okay, so the first question asks, can landlords raise rent during this time with COVID moratoriums?
Sure. In this area, I think it's 7.2%, 7.3%. You can raise rent twice a year. You can raise rent up to 5% plus the CPI that is set by the Department of Industrial something or other in April. And this year, I believe in this particular region, it was 2.2 or 2.3%. So you can do a 4% and then a 3.2%, but in any given calendar year, you cannot go over. The other thing to remember, if you don't raise rent this year, you lose it. It's not a rollover kind of a situation. So yeah, you can raise rent. Now, obviously, if I'm going to raise rent on a COVID tenant who's claiming, COVID relief, there's a practical question there as to why would I do that. But I'm not concerned, or I don't see any reason why you can. The 3088 didn't deal with rental increases that I'm aware of. And I've read that act because it's so poorly drafted. I've read that act many, many times. Other question? Go ahead.
Yeah, somebody asked about the latest version of the Code of Ethics, and Connie did post a link in that into the chat. So the Code of Ethics are available on the National Association's website. And then there was another question here. It says, we all agree that home purchase is an emotional decision. Selling is also.
I'm having a hard time hearing you, so slow down a little bit. I'm old. Okay.
Sure. Sorry about that.
No problem.
They don't understand why buyers can't legally write letters to the sellers.
They can. I can write a letter. I can write a 100-page letter if I want. What I can't do is write a letter that creates fair housing issues. That says, I'm white, choose me. Those are what we're talking about. Or I'll keep the morals of the community up because I'm married to a woman. Or whatever it might be. You gotta, again. Katie sent us a number of examples of things where those states in that particular area inquired. And I'm not telling you that I think this has not gone overboard, or that with the new administration it's not even going to get crazier, or in California it's not already insane. I'm not saying that. I'm not making a subjective, quantifiable opinion. I'm just saying, let me give you an example, right? I can't wait to decorate that house for Christmas. Is that a religious issue, right? Or again, I'm not arguing that, some of these things have gone too far. But my job is to tell you what the law is and how you can get in trouble. You figure it out for yourself after that. I believe that you can write a letter, right? I can say, hey, Carol, I understand what your concern is about fair housing. So make it clear in the MLS that they're to stay away from anything related to these 9 or those 22 categories, right? I can do that. So again, don't misstate what I just said. You can write the letter. Now, from a risk management perspective, right? I hope you write all kinds of letters because I'm a lawyer and we defend you and you pay us to do that. And what we're trying to say to you is, look, manage your risk as best as you can. Be very careful. But I never said you can't write the letter. Go ahead. Next question.
Sure. Right along the same lines, what if a person identifies as a military family? Would that be along the same protected categories?
That's not a violation of any of the 9 categories that I'm aware of. Here's the problem, is that it could create some reverse discrimination because military families are protected under California law. So while that wouldn't be an Article 10 violation, there's a new statute that protects military veterans and families, particularly in rentals, but also I could see in purchases. But no, I don't think that'd be a problem. You know, as a veteran, you know, blah, or maybe I know that you're a veteran and I'll say, you know, as veterans, we blah, 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 blah. I mean, I could see that being done, and I don't think that's a violation of anything.
Okay, fair enough. Thank you. There is a question about the rent increase. So they asked,
sorry, Daniel, time out. I forgot to say this. It's right here on my notes, so I'm going to say it now. And this is retroactive to the very beginning. I'm not giving anyone legal advice today. I'm not speaking on behalf of the board or Connie or staff, and I am speaking not to the standard of care, but to aspirational issues, right? I don't want to see, we defend cases all the time. You know, the law firm Tyler Burst, we defend cases all the time. We usually win, right? And so I'm not worried about that, but I know what it costs to defend these cases, right? And while I'm certainly happy to accept your money, and any lawyer would be, the fact is that even if you win, it's going to cost you money, time, and psychological damage, right? That's what I'm trying to say here. So I'm speaking at a much different level than what might end up being, you know, where you're found not guilty by a jury or by the administrative agency. So I just want you to make it clear. Sorry, Daniel, go ahead.
quite all right. So the next question is regards to the rent cap. Can't properties that are exempt from the rent cap have rent raised more than 7%?
Say again?
Can't properties that are exempt from the rent cap have their rent raised more than 7%?
Yeah, but keep in mind, they changed the exemptions under 3088, at least temporarily, to February. So you got to be careful you're really exempt. Now, if you're in Temecula, Murrieta, Canyon Lake, those places, you're okay. But if you go outside, like I did yesterday, I had the same kind of a meeting with the people up in LA. And now you got to go to local jurisdictions because there's 140 different jurisdictional issues in terms of rent control, and that have gone beyond the 1482, which was the rent control law that went into effect on January the 1st. So you got to be careful. We're, because of Gino and because of Adam and all the other people, the board, you guys have been able to keep pretty tight rein on government gone crazy. But if you go outside this jurisdictional area, you better know what you can do. But yeah, you can raise rents, frankly, to whatever the market will bear. If you raise it by 10% or more, you have to give a 90-day notice of your intent to do that. And that's a statute that went into effect on January the 1st. Okay, so if I have an exempt property, yes, you can raise the rent by more than 7.2 or 3%. But if it's going to be more than 10%, then you need to do that with a 90-day notice. Okay. Go ahead.
So my microphone is not very good apparently, so I'm going to unmute or allow everyone to unmute themselves if they'd like, and then if they want to ask their question directly.
Okay, I'm fine with that. I wanted to go over a little bit of some of these questions myself, so I'm looking for them as I fumble through my paperwork here. I've got a bunch of questions that came in that Sylvia sent me, so you know, I want to make sure I accommodate those people because they took the time to actually write out their questions and send them in advance, and so I want to make sure I touch on those questions, which I'll be danged if I can find right now. But go ahead, I'll be looking for them while you're talking. Here we go. I found them. Okay, go ahead. I'll answer a question since I was, you know, somebody's waiting. Unmute them and let me see.
Let's have them raise their hands, Daniel.
All right, let me answer a question that came up the other day. I have entered into the cash for keys, deferred rent, some type of a written agreement with my tenant. That it could be a full-on cash for keys, it could be a partial payment plan, it could be a deferred payment, whatever it is, I've done that. And it is, and the debt that you owe me is related to one of the two transition periods, either March 1st to August 31st and or September 1st to January 31st, okay? So right now up to through November. and then the tenant breaches that agreement, can I evict them? No. It's a breach of contract. Why? Because under a bunch of laws, including 3088, you cannot waive rights that are given to you by the legislature. And a breach of contract is not grounds for eviction under any law, right? Unless it's a breach of contract specific to the lease. I know that sounds complicated, but how do I say that? What you need to understand is that the primary reason people get evicted is for breach of the contract that says, I will pay you $2,000 a month, right? That's the contract. 3088 eliminated that as grounds for eviction during that transition period. So what if I rent a house to Bill doesn't pay me, and the reason he doesn't pay me is related to COVID, and that's a very broad term, then I cannot evict Bill for non-payment of rent under most circumstances. What I would have to do is find some other reason to evict Bill, so long as I'm not retaliating because he's not paying the rent, right? So that's the way that works. It is not, I didn't think it was, and I was confirmed to me by an attorney at CAR, and he gave me the reasons, and it was very clear to me after that. So there's that. I've got a couple of other questions, but if you got any more questions, I'll bounce back and forth between yours and mine.
Hopefully this microphone sounds a lot better, but I do not have any other questions at this time.
All right, then I have a question here. This is a long one, but it's a good one. This question is regarding a tenant who's missed his payments. So the HOA contacted me regarding his 2 dogs due to a complaint from a neighbor. So right away, the first question I'm going to ask is what? Are the dogs protected by the Americans with Disability Act? First thing I want to know, because there's different rules for different kinds of dogs, right? If it's a service animal, or because the HOA could have a no pet policy. The apartment owner could have a no pet policy. There's a case called NARSTAT, which says that an HOA can have in its CC&Rs a no pet policy. Perfectly valid. However, first question I want to find out is the dog a pet, or is it a service or companion animal? Because service and companion animals under the new fair housing regulations are not pets. Okay, they are not pets. So if Janice, if you got that little boopsie dog that you have right? That little boopsie dog, if that's a companion animal, is not your pet. It is something that you use to control. And I'm not saying you do. I'm just picking on you because you're my friend. Okay. But if you did that, because that dog gives you some type of psychological or other anxiety protection, if that's true, then that's not your pet. That is your medicine. No different than if I take metformin for my diabetes, or if I take insulin shots, or whatever it is. It's no different. If it's a service animal, it goes even further, because the service animal is replacing some aspect of what I can no longer or could never do for myself. Traditionally, I just changed a document for a client because they had a rental agreement that said seeing eye dogs are an exception to our no dog policy. Well, it isn't seeing eye dogs anymore. It's service animals, right? Because they do much more than seeing eye. So anyway, that's the first question I'd want to know. And then if it's a pet, truly a pet, then you can govern it in whatever ways you need to. But even if it's a service animal, I represent the animal shelter, full disclosure, I represent Animal Friends of the Valley, since they were formed, basically. Just because it's a service animal and or a companion animal, it does not relieve the owner of the responsibility of complying with all of the regulations that are reasonable in nature. So for example, getting microchipped, or having a tag, or having vaccines, or whatever it might be, those are not eliminated from. If I'm a blind person, my dog still needs to comply with the law. Okay, but it's not a pet. So I think that answers most of that question. I have
John, we have a question. We have a question.
Go ahead.
Okay, well, I'll ask it real quick. So there's a question
Okay.
for
Hi,
you to
Daniel. I'm
clarify
here.
the lockbox and MLS the seller instructions. Like, you went over that earlier and they wanted to ask clarification on that.
I don't know the clarification because I haven't talked to let me see if he sent me a letter. I haven't talked to the lawyer yet for the MLS, but as I understand it, and again, I because there's so many different facets. I own property in Tennessee. In Tennessee, in order to be a member of the multiple listing service, I must first join the board. I must, no option. In California, I can go straight to the MLS. In CRMLS, I have to go through one of the associations and become what we call an MLO, or multiple listing only member. Okay, I can do that. So there's different rules for different jurisdictions. So that's all got to be sorted out. But the way I read what was written in Inman today is that even if I don't belong to CRMLS, I still must be given access to the lockbox. I'm hoping that it isn't as broad as that, because that's insane. How do you guys monitor that, right? I know who comes into I don't have a lockbox on my house because I don't want strangers coming into my house without some control. But if I had a lockbox, right, now all of a sudden the world has access. And I will tell you, and I know Connie has to deal with this all the time. People that give lockbox codes or combination lockbox codes to their clients and say, go take a look at it, right? I know it happens out here from people from Orange County and Long Beach. It happens up in Big Bear all the time because the realtor from down the hill is too lazy to drive up there, right? Whatever, but people do that. So now all of a sudden, I'm one of these non-MLS, that means I don't even abide by the MLS rules, let alone the code of ethics. Now I get a lockbox combination, right? And I turn it over to my client. What are the penalties going to be for that? How are we going to monitor? How's Connie going to deal with that? Right? So I don't know the answer to those questions. That just happened this morning. We'll get some film, and obviously I'm hoping that those rules will not go into effect tomorrow, but we'll see. I'm sure there's going to be some issues. There is a meeting that both Connie and I will attend on Monday. It's the board of directors meeting for CRMLS, and I'm going to guess this will be a topic of conversation. So we'll see how that plays out. Any other questions? We got 59 chats. So you guys have been busy little beavers. Here's a question that came up, and I'm not sure I'm going to give you the right answer because I don't do family law. I didn't go to law school to get family to deal with furniture and dividing. So I didn't do that. So I'm going to give you my best guess. Husband and wife own two properties. Husband got arrested, and the DA put some kind of a lien on both properties to ensure possible restitution to victims. Is that constitutional? I know sorry, my gardener's here today. Apologize for that. I'm too lazy to mow my own lawn. There is a case before the California Supreme Court. As you all know, a couple weeks ago, we voted to keep the bail system in place, right? We rejected the legislature's desire to get rid of bail. But the Supreme Court of California is taking up a separate case under separate rules to determine whether or not bail is constitutional, because if I can afford bail and Ellen can't afford bail, right? How's that fair, right? She gets stuck in jail. We're accused of the same crime, right? That's the argument, okay? So here's my question. Is this going to fall under that constitutional restriction? That's just my real estate thought. But assuming that the DA can even do that, then 1 year later, the husband and the wife divorced. So clearly it was apparently community property at the time of the arrest, and now they get divorced. The case is still not resolved. I assume she means the criminal case. And thereafter, and the divorce is final, everything's done. Both homes have been awarded to the ex-wife. Ex-husband signs them both over via the proper grant deed. Wife signs both grant deeds into her family trust, and both homes are now in the trust. What happens to the homes if the husband is found guilty? Let me guess. If California is a community property state, the question is going to be, is the wife's one half of the community a part of I mean, what she's going to argue is minimally half of that free and clear because I didn't commit the crime, right? And I don't know how a divorce lawyer would handle that. That's an interesting case. I would have to defer to a family attorney. But from a real estate perspective, if Lisa and I own a property together as tenants in common, and I'm arrested, she's not. She's going to be affected, right? Because there's a claim to the property that could push through to her. But if there was a partition of that property, she would still get to keep her half. So I'm not really sure how to answer that from the standpoint of a family law case. I would raise a whole bunch of issues if I were the family law attorney, constitutional and so forth. But there's a lot of facts that I'm not sure of. Does the passive method? This question comes up. I know that Barbara teaches the RPA class for you guys. I teach it other places, and I get this question every single time. Okay, does the passive method of removal still exist for removing contingencies? If a contingency removal are not signed after the time is over, are the contingencies still in effect? Here we go. Passive, you know what? Do I have to explain to anybody the difference between passive and active removal? Active removal is what's provided for in the current RPA and is going to be remaining in the new RPA. So that's not changing. So yes, it is active. What active means is that before the seller can cancel because the buyer failed to either satisfy and or remove the contingencies, they must first take an action, and that action, of course, is to send out a notice to perform. That's active removal. Once they do that, then 2 days later, they can go down and cancel escrow, and now you're off to the races on issues relating to the deposit and all that cool stuff, okay? That's active removal. And so in the contract itself, CAR specifically eliminated a decade ago passive removal. What passive removal says is that Carol and I have entered into a contract. I picked on Carol already, so I'm going to pick on Lisa again. So Lisa and I have entered into a contract, and what we did is we modified the RPA, and we said in an addendum or in some other document that all contingencies will be removed, or however we set it up, 15 days after acceptance, right? That's passive removal. That's not unlawful. It's just not part of your contract. So you can negotiate that. But if you do, you better make sure your lawyer has signed off on whatever document you use, because you're practicing law without a license at that point. And so be very, very careful of that. But you can do that. And then, of course, depending upon which method you're using, if you're using the method that is set forth in the current and future RPA, then no contingencies get removed. And it says this in the body of the contract under paragraph 14, I believe it is, that no contingencies are removed without first taking the step of requesting a removal of the contingency. And so contingencies can technically remain in effect if the seller never takes an action until the close of escrow, in which everything merges together, right? They're going to be pretty upset with you if they find out that that happened and you never did anything, but it's basically serving a notice to perform, okay? And I miss teaching the RPA class. We don't do that right now because of the COVID situation, but that's why I recommend that you use the delivery of notices form, because you can set up how you're going to deliver those notices and make it easy on yourself. So the answer is, does the passive method still exist? Yes, just not in your contract. And is the contingency removal, if I don't do it, are the contingencies still in effect? Probably yes. Okay, so I've answered that question. Another question came up. How long after an incident of sexual harassment can a person file a complaint that happened in a workplace environment? I believe the statute is 1 year. Bill, I'm not sure if you know, but if Bob is in the office next door, run in there and ask him. But I think it's 1 year. So that's, but there was talk about extending it, and I don't think they did in this session, but next year it'll probably jump to 2. Okay, and so if you're sexually harassed in the workplace environment, it's 2 years. If it's at the board, it's 180 days because we have restrictions on when we can bring ethical claims. Okay, all right. Let me see if I covered everything.
I do have a couple, John.
Go ahead.
Okay, so one question here is, how much increased rent on a Section 8 property per year? Like, how much can you raise it?
Depending upon the area, assuming it's not an exempt property in the Temecula Valley, Southwest region, it's the industrial relations people said that the CPI this last year was, I believe it was 2.2 or 2.3%. Somebody can correct me on that. And so that means you can raise it 5% plus the 2.1, 2.2, whatever it is. So 7.2, 7.3%, whatever it is. Now, if I'm down in San Diego, it was 1.4%. If I'm up in some areas up in Northern California, it was a lot higher. It's going to be interesting to see what CPI does this year with COVID. I suspect that we're not going to see much of a jump in CPI, but things could change before April. So for right now, I just found out today turkey costs are down 4%. That's a good thing, right? I was almost made a bad joke. I'm not going to do it. I'm going to resist. It had to do with the French Laundry, but I'm not going to say it. But it was pretty funny. Anyway, so that's kind of what's going on right now, kids. We got fair housing issues. You've got new forms coming out second week of December. A bunch of new laws going into effect that have nothing. Make sure your websites are compliant. Make sure you read the CDC BPP. The B, yeah, is it BPP or BBB? Whatever it is, the best practices thing that you guys have that's online from NAR or from CAR. A couple of other things, real quick. I've been having some conversations with some plaintiffs' lawyers recently. I don't sue anybody anymore. They put me out to pasture. I don't handle litigation. Much smarter people in Tyler Bursch handle the litigation now. But the issues come up a lot. I did a couple of programs with some risk management lawyers, and I'm part of a risk management team at CAR. In fact, we're going to have that meeting next week that I told you about, the 4th of December. What are we looking at for legal trends relative to issues like fiduciary duty and all that in light of COVID and in light of all the issues you guys have had to face? And it's going to be an interesting academic question. Let me make sure you guys understand what we're talking about here, okay? Under California and almost every other state's law, liability, which is the word you guys use. I hear it all the time. Am I liable? Can I be liable? I hear that. It's not the right inquiry. It is duty, breach, causation, damages. Okay, all 4 of those elements have to be proved by the plaintiff in order for you to be found liable. So what are we looking at? What do we think is going to happen? What are we going to talk about on December the 4th? Obviously, duty, right? Typically, duty was set by statute. You have to do a reasonably competent, diligent visual inspection. All of the things you're supposed to do, make sure that the right forms are given out, the TDS, the SPQ, all the stuff that you guys do. But now, for the last couple of months, we've been looking at all kinds of other issues, haven't we? Right? The duty to keep the house clean, the duty to inform if someone got sick in the house, all these kinds of issues. So, and there's a case that just came down. It wasn't published. It's called Catalano. CAR has asked the court to reconsider and to publish it so we can use it as a precedent, because it was one of those very few cases that actually was resolved in your favor. And it had to do with the limitation on fiduciary duty. What happened in that case was and again, you know how I feel about fiduciary duty. you're basically, trying to serve two masters at the same time. I understand the financial implications of it. Think about this, right? I'm representing, or Lisa's representing me, and she's representing Carol. And when we do the prenuptial agreement, which you guys call the RPA, we're all in love. But in many transactions, at some point in time, does Lisa not have to make a choice, right? And that's what happened in Catalano. The buyer didn't close on time. The seller provided a demand to close escrow, and they did it about 6 hours earlier than the contract allowed. And the buyer sued the agent for breach of fiduciary duty because the agent, who was representing both the seller and the buyer, sent in a notice to perform, which the seller instructed them to do. And the realtor won that case because the buyer was unable to prove any causal connection. Remember, duty, breach, causation, damages. Was not unable to prove any causation between the damages that they were alleging and the fact that they got a notice 6 hours too early, because the bank made it pretty clear they weren't going to have the loan for at least a couple of more days. Okay, so we're looking at that, but we're looking at it in the context of all these property management issues that have been coming up, all of these issues relating to delays in closing and cancellations and who gets the deposit. So, and of course, who got sick, right? Did somebody get sick because they went into a house? Did somebody get sick? Did somebody die? What kind of disclosure issues? All that kind of stuff. So there's duty, breach. What's the standard of care, right? Is the standard of care the CDC guidelines? In Tennessee, there's a rule that if you follow the rules, which are minimal, you have a safe harbor. If you can establish you followed the rules, then it's much more difficult for a plaintiff to prove. We have no such safe harbor laws here in California. Therefore, I can't even tell you what that might be. Then, of course, causation. I got sick and I sued Janice because her listing someone had COVID. How do I prove I got sick in that house, right? And then, of course, damages means money. Okay, so those kinds of issues we're discussing right now. We'll give you a film at 11 once we start making some decisions and start seeing what the courts are going to do. But of course, I think I mentioned, I was just talking to one of the attorneys in the office. He's handling a slander of title case for me, and he has a May 22 trial date on this case. So, it's going to be tough. The courts are going to be clogged. One of the things I want to touch on before I leave is this whole idea of this 3088, and then I'll let you guys go. I know I'm 5 minutes over, and I apologize. Remember, debt that is COVID related, in other words, rental debt that is COVID related, cannot be grounds for eviction. But I still owe you the money, right? So Michelle, I still owe you for rent from whenever I stop paying, including the 75% if I end up paying you the 25% from the second transition period. A couple things. Number one, remember that this bill sunsets on January 31st. I would like to go down to Pechanga. I don't know if they're open. I would like to go to Pechanga and place a substantial bet that the legislature will extend that statute past the February 1st date. But if they don't, that's the date that statute sunsets, and we're back to the old way of doing things. All the other laws and the suspensions and the changes all go back, except for the debt that was owed. Secondly, the definition of COVID related is very broad, right? I've been working on, I'll make up, okay? Actually heard the story today. I'm working, I'm fine, I'm good. I haven't missed a paycheck. But my wife works for an after school program that has been suspended. So our family has sustained a reduction in income due to COVID. I qualify. Okay, period, end of story. Or Or the school, I have no way of handling childcare, so now I have to stay home. And because I'm working from home, I've taken a pay cut or something like that. Those are the kinds of things. So that's going to be pretty clear. And then lastly, and this is, I can't answer this question for you. I can just remind you. I am a renter. I don't own a house. I'm renting from you. I have a relatively low paying job. I'm one of the people that's been very much victimized by that, right? As you know, I own the Stampede. We're in the process of not owning the Stampede anymore, but for right now I own it. All my poor waitresses, now we've paid some of our people, but we haven't been able to pay them all, because there's a lot of people. So those people are out of work, right? Now, I'm using credit cards to live. I'm raising debt. Now, all of a sudden, you take me to small claims court. And let's say it's after March 1st. For more than $10,000, you get a judgment against me. It's not going to lead to me getting out of the house. I'm still going to have the same financial problems, but you can't evict me. You have a paper judgment. Now, what does that mean? That means you have to garnish my wages. Well, my wages are pretty small. Or you can go after assets. Well, probably have an exemption on my car because I needed to get back and forth to work. You get my point? Or I'm going to waltz down to a bankruptcy attorney and I'm going to file bankruptcy. And I'm going to eliminate all my non-fraudulent debt in a Chapter 7 and I'm done with you. And there's not a thing you're going to be able to do about it. The reason I point that out, for those of you that are involved in this world, negotiate with those people. Try and get a cash for keys. Get possession back. The primary purpose of an unlawful detainer has always been to get possession, right? So get possession any way you can legally, because the retaliating fees or punishment for retaliating or for not following the law are substantial, up to $2,500 a day. So do it legally, get a cash for keys, right? Tell them, look, if you move out, I will forgive, and then negotiate it. And then use the proper forms. There's one of those 12 will fit your bill. Use those forms and get them out. It isn't about fairness. It's about economic practicality. And I will end with that. I see there's 68 chats. I have no idea what that means. But I hope I didn't throw too much at you guys today, but it's a tough, it's tough out there, kids. Do your best. And unless there's no more questions, I guess I will let you all go try and make some money.
Hey, John, I've got a question for you.
Who's that?
Max.
I don't see you, but go ahead.
Well, I'm not, never mind. Anyway, the question was in regards to these love letters that you were talking about. I just received my second love letter in 48 years in the business.
No comments, Matt.
There was only one offer. So do I even have to present that love letter?
Probably, unless you agreed in advance with your seller. But what you want to do is make sure there's nothing in those letters that would even remotely look like a fair housing issue. And again, you're going to have to be the judge of that. Talk to your broker. She's pretty sharp, and we'll sort it out. But yeah, I believe you have to. Again, that's why I'm saying sit down with your listing people, and you don't have to. If you've already got the listing, and it doesn't mean you can't go back and talk to your sellers, right? You can always do that. You can always modify the relationship. You can say, look, this crazy lawyer from our board just said blah, 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 and it makes sense to me, and I don't want you to get in trouble, and I don't want to get in trouble. So can we agree that if somebody does send you, and you don't have to wait or just do it for new listings, you can go to these people and say, this issue has come up, and if the lockbox thing turns out to be what it looks like on the surface, and I know, Denise, you've read the same thing I just read, and Connie, it looks to me like it's not too cool. And so you're going to have to go back to your sellers and say the same thing with the lockbox, right? But anyway.
Well, I did present the love letter, by the way, and first I presented the offer and then I gave her the love letter.
That's fine. I mean,
I felt
again, just
that was more prudent.
hopefully they don't contain anything of a fair housing nature.
Oh,
If
no.
not, then tell Debbie to give me a call.
No, it had nothing to do with it. And the escrow's closed and everybody loves each other.
Yeah, remember, you represent clients. There was a case that came out of Maryland. It's really kind of a scary case. I'm a couple, a Caucasian couple were looking to buy a property, and their realtor was black. Three of them went to a house. The listing agent wasn't there, but the sellers were home, and the sellers let them in. But when the sellers opened the door, they saw the black realtor, and they said, "You can't come in." So that realtor called the listing broker and said, "Hey, this just happened. You need to be aware of it." And her comment was, "Well, it's seller's choice not to let you in." And that realtor just happened that the black realtor was the president of the Maryland Association of Realtors. Bad timing. So that case ended up being one of the cases that was used at the NAR meetings to talk about this whole concept of when am I a participant? Because remember, the statute has always, the Code of Ethics has always said you're not to engage in a plan, right? And so if Lisa is perfectly fine in everything she does, but she allows her clients to go unfettered in terms of, being racist or homophobic, or I hate that term. I have no idea what that means, but they act in a certain way. Then can she get into trouble? And that's going to be the kind of stuff we're going to try to keep you guys posted on. I'm looking forward to the meetings I'm going to be having week after next with all my professional standards people, because they're pretty smart people. Those of you that do professional standards, these are going to be interesting conversations, aren't they? Anyway,
John?
I'm done.
Oh, I have a question. Is it okay to still ask?
I mean, I got nothing else to do. Nobody likes me, so I'll stick around. But sure, I have a 6 o'clock appointment, I believe. Have
a happy Thanksgiving, everyone.
I have
yeah, if you guys got to leave, I understand. Take off, and we'll watch your numbers dwindle as we speak. But Sandy, go ahead, ask your question.
Okay. Thanks, John. Okay, so I on vacant houses, we're supposed to get PEAT forms as well, correct?
Correct.
So now, what if the house is vacant and an agent just goes and shows it and does not send the PEAT form? Now, what happens then? I mean, obviously,
hold your breath. I mean, technically, it's a violation, but the bottom line here is the purpose of the PEAT form is to assure the owner that it's been represented to the realtor that the people coming into their house are not infected with the disease. Certainly afterwards, what I would do is, go in and clean it, do the things that the CDC says you're supposed to do. Typically you've been delegating those duties either to the seller or to, cleaning service or whatever, or not doing it at all. Frankly, that's what I've been seeing. But take whatever steps you need to take. Because again, it's that old Clint Eastwood adage, well, punk, do you feel lucky? And so, it's that one situation, and that's really what's been happening with the DRE is that one situation where somebody, we have a couple of really, you can't teach stupid. We all know that, right? And there are some incredibly stupid people out there. We had one guy actually put it in his agent remarks, "I'm not cleaning. These are stupid laws. I'm not doing it." Well, not doing it's one thing. Telling everybody you're not going to do it is incredibly stupid. So, those things are happening, and those people are getting themselves in some trouble. But I don't. Again, it's probably a no harm. Just go in and make sure the place gets clean. That's what I would do, just to be safe. Because if somebody does get sick, the first thing they're going to do is look for every pocket they can find. Right? I mean, that's what they're going to do. So, protect yourselves the best you can. It's a tough time out there because, again, we don't know what the extent of your duty is or what the breach of the standard of care might be. And it might be a lot lower than what I'm talking about today. I hope so, for your sakes, but, I don't know. By the way, I wanted to mention something. It's totally unrelated, but Barbara, you need to hear this. I talked to Ed Zorn, your MLS, the MLS attorney, you know, you're gonna have a 16-page contract next year, of which the first 4 or 5 pages is basically the offer. It's, you know, like that form that you have right now, that matrix where you can summarize 4 or 5 offers, or even one offer. You have a couple of forms. That's going to be what the first 4 or 5 pages look like. And I can't share it with you right now. I could before, you know, Barbara's got a copy of it, a couple of other people, but I think, Joe, I sent it to you, but right now they're still working on it. They decided to go back to the drawing board on a couple of things. But what Ed said is that the Glide's going to work on a program so that, and I don't know how it works. I've never used Glide because I'm not a realtor, and frankly, I have a hard enough time attaching things to emails. So but there's going to be a way through Glide that you're going to be able to auto-populate a lot of that stuff. So just be aware that when Barbara and I teach the class sometime in the summer, we're going to be, she'll tell you how that all works. Not me. So that's going to be happening next year. All right. Any other questions? If not,
Yeah, John, I got a question for you.
what do you want?
I should have asked when you're here, but it's a good question for everyone to kind of
Bill
hear.
Tyler is Bob Tyler's brother, and we share, well, actually, we haven't shared office space in almost a year because I'm working
Right.
at home because I like it's nice and quiet here and I can play with my dogs in the daytime. But go ahead, Bill.
In the MLS, I see it as somewhat concerning, but in the MLS under the agent remarks, you know, we know that under the PED and with the COVID, you know, we can ask for a pre-approval letter before someone enters a home to view it.
Actually recommended.
Recommended. But what we're seeing, and I'm just wondering what your thoughts are on it, is that a lot of agents are asking for a pre-approval letter, proof of funds. Some are asking for a DUs, which is a computerized approval from an underwriter. And some are still asking for FICO scores before they're going to show the house. And I just see that as,
In other words, what we're trying to do is double in the deal by eliminating all the potential buyers that might be coming in from another agent. So here's the deal.
I just think
Here's
that
the
there's
deal.
a lot of confidential
The
information.
seller, subject to your advice and your recommendations, the seller decides, my house is on the market right now, right? Because I'm building another house. And I set the terms. Obviously, I set the terms based on recommendations, based on information, based on, you know, all that. But it's my house. Now, having said that, you can go overboard. The DRE actually filed a claim against a realtor in your area because she was asking for pre-approval letters from a specific brokerage, a specific loan broker. And they accused her of steering, and we had to affirmatively prove that there was no money exchanging hands, nothing of value, that it was not a RESPA violation, it was not a violation. If the seller has said, you know, I want a pre-approval letter, how do you get a proof of? I'm asking because I'm not as smart as the